Morning. In a recent video entitled Issuing a Plaintiff's Claim, we saw that there can be two kinds of damages: liquidated damages and unliquidated damages. Liquidated damages are damages that are fixed or predetermined, such as unpaid accounts for goods and services rendered, loans, commercial rent, perhaps NSF checks. Whereas unliquidated damages are situations in which those damages are not fixed or predetermined, such as property damage, personal injury, and some forms of breach of contract. In today's video, we're going to be examining the process required to obtain a default judgment in an action for liquidated damages. Now, in order to obtain default judgment under Rule 11 of the Small Claims Court rules, we need to satisfy three prerequisites. Number one, 20 days must have elapsed since effectively serving the plaintiff's claim on the defendant. Number two, the defendant must have not filed a defense within that 20 days. And number three, the defendant must not be a person under disability. Provided that we can satisfy those three requirements, we are ready to go ahead and obtain our default judgment. To start the process of obtaining a default judgment under Rule 11 of the Small Claims Court rules, we're going to need to access some Small Claims Court forms. The first form that we need to access is Form 9B, which is a request to clerk. Now, request to clerk is a very simple form. All we need to do is fill in the title of proceedings. We need to address the request to the appropriate court clerk. In this case, it's the clerk of the Toronto Small Claims Court. We're going to check off the very first box, which simply requests that the clerk note the defendants in default for failing to file a defense within the prescribed time period. We then date the form and sign it, and this form is complete. Next, what we're going to do is complete an affidavit of service. So once again, we type in the title of proceedings. Now, in this case, for the purpose of our example, we're going to assume that the plaintiff's claim was served by a process server by the name of Alada Papers. Now, Ms. Papers resides in Toronto, Ontario, so she's going to state that in her affidavit, and in paragraph 1 she's simply going to say that she served, in this case it's the corporation, on January 25th, 2018 at 222 Great Eats Avenue, Toronto, which is the address of the corporation's place of business, with the plaintiff's claim. Now, because this is a corporation, it's quite common to effect service of a plaintiff's claim by personal service. And because a corporation is just an entity created by statute, we need to have the plaintiff's claim served on a live individual. So in this case, we have to complete paragraph number 2. And in this case, Ms. Papers is going to be stating, I serve the documents referred to in paragraph 1 by the following method. And in this case, she's going to check off the box by leaving a copy with Marie Antoinette Jolly, Restaurant Maitre D. And it basically says that Marie Antoinette appeared to be in control and management of the place of business. Now, Marie Antoinette can be someone who just works there. In this case, perhaps she's Joseph Jolly's wife or a life partner, or maybe some other family member. Now, that's it. I mean, we can see here that there are other forms of service that have boxes that can be checked off, but again, it depends upon the type of document which is being served. Some of these forms of service would not apply to our situation where we're serving a plaintiff's claim on a corporation. Now there would be a second affidavit of service that would need to be prepared with respect to the claim and its service on Joseph Jolly. Now, this form will be signed by Ms. Papers and it will be commissioned by a commissioner for taking affidavits. Now, sometimes there is another document called an affidavit for jurisdiction. Now, affidavits for jurisdiction typically are required in situations where all of the defendants are being served with the plaintiff's claim outside of the court's territorial jurisdiction. But sometimes a clerk may request an affidavit for jurisdiction if even one of the defendants is being served outside of the court's territorial jurisdiction. Very simple document to fill in and to complete. Now, one of the nice things about obtaining default judgment for a liquidated sum is that a judge does not have to sign judgment. A clerk of the court can sign judgment. So when filing your request to court clerk to note default and your affidavit of service or affidavits of service and potentially your affidavit of jurisdiction, you'll also want to present to the court clerk several copies of the default judgment. Now, the title of proceedings is similar to that as found in the plaintiff's claim, and you might remember that we do have additional defendants listed on an attached form, so always remember to attach the additional parties form to the default judgment. And once the title of proceedings is complete, we'll check off this box which says to the defendant or defendants, you have been noted in default according to Rule 11.01. Default judgment is given against the following defendants. We're going to fill this in, and in this case we're going to assume that both the corporation and Joseph Jolly have failed to file their defense within the prescribed time period. Next, we need to calculate the amount of the default judgment. You may remember that in the plaintiff's claim we were suing for $12,000 on account of goods that were rendered, but the invoices were left unpaid. So we're going to type in the amount of $12,000 as being the principal amount of the debt. In Part B, we're going to claim for prejudgment interest. Now, you might remember when we completed the plaintiff's claim, we had to choose from two options. If in fact our client, Superior Paper, had entered an agreement with the corporation and Joseph Jolly that a certain amount of interest would be charged on overdue accounts, then we would use that amount of interest in our plaintiff's claim, and we would also use it here in our default judgment. But you may remember that we were assuming that no such rate of interest had been agreed upon, and therefore we were going to claim interest under the Courts of Justice Act. So when claiming prejudgment and post-judgment interest in our default judgment, we simply state that prejudgment interest calculated on the sum of $12,000 at the rate of, now this is where we need to stop. We need to find out what is the prejudgment and post-judgment rate of interest under the Courts of Justice Act. Now, that's quite easy. All we do is we Google prejudgment interest. And when prejudgment interest is Googled, what we get is a site which is posted by the Ontario Ministry of the Attorney General, and it just happens to be post-judgment and prejudgment interest rates. There are two charts. The first chart is post-judgment interest rates, and you can see here that the rate is broken down on a yearly basis between 4 quarters. Now, which of the quarters that applies to us depends upon which quarter we issued our claim. So we can see for post-judgment interest it starts back in 1985, but that's of no use to us. We issued our claim in 2018, so we scroll down until we hit 2018. We also issued our claim in the first quarter of 2018, so what this chart tells us is that our post-judgment interest rate will be 3%. If we scroll down further, we find the chart for pre-judgment interest. And again, we want to scroll down to 2018, and we can see that in the first quarter of 2018, pre-judgment interest was 1.3%. So we can bring those two figures with us, and we can complete the default judgment. So we'll put in the 1.3% under prejudgment interest. Now what we're going to do is, when we calculate the period of time that the 1.3% covers, we start with the date on which we issued our plaintiff's claim. In this case, it's going to be January 23rd of 2018. Now, it says 2. Now, here's what we do here. When we're preparing this form, we sort of have to look into the future and calculate when we're going to be filing this form. So if we believe that this form, or default judgment, is going to be issued and entered on March the 12th, we're going to type in March the 12th, and then we're going to calculate the number of days between the date that the plaintiff's claim is issued and the date that the default judgment is issued and entered. And in this case, being 49 days, what we do then is we take $12,000, we multiply it by 1.3%, we multiply that figure by 49 days, and then we divide by 365 days, being the number of days in each calendar year, and that will provide us with the prejudgment interest amount, in this case $20.94. Now, we're also able to obtain an award for costs, and in this case we're going to claim the court filing fee that our client incurred to issue the plaintiff's claim. You might remember that as an infrequent user, the client paid $95 to issue the claim. Also, to obtain this default judgment, we're going to have to pay an additional court filing fee of $55. At least that's the amount of the court filing fee at the time of this video. So we take the $95 and we add to it the $55, but since we had the plaintiff's claim served on 2 defendants by a professional process server, we're also entitled to recoup some of those costs. Now, to my knowledge, we can claim a maximum of $60 for each person served. Now, that at least is the amount that it was the last time I checked. You may want to check to see whether or not the $60 has been increased. That is always a possibility. In this case, we're going to assume that the maximum is still at $60. So if our process server, for instance, charged us $60 or more to serve each of the 2 defendants, what we're going to do is we're going to claim a total of $120, or $60 twice. So we have $95 plus $55 plus $60 to serve the corporation, another $60 to serve Joseph Jolly, and that calculates to $270. So if we add these 3 amounts, our principal amount, our prejudgment interest, and our costs, it comes to $12,290.94. Then next we just fill in the post-judgment interest, which will accrue on our judgment, and as we saw, that is 3%. It's dated, it's signed by the clerk, and there you have it. You have a default judgment. But let's just stop here for a second, because there are a couple problems that sometimes arise. Although a clerk can sign a default judgment for a liquidated amount, we have to remember that the clerk needs something on which to base that judgment. And that's why it's important, when we issue a plaintiff's claim for a liquidated sum, that we attach documentation in support of our claim. Now, that documentation may include, for instance, in our case, outstanding invoices amounting to $12,000, or in other cases it may include perhaps a loan agreement or a promissory note. But in any event, we need to be able to demonstrate to the clerk that the amount we're claiming is in fact outstanding. Now there is a second issue that needs to be addressed. You might remember that when we issued our plaintiff's claim, we made a point of stating not only the proper names of our defendants, but also other names by which they're known by. Now, if, for instance, we had an invoice, or we issued our $12,000 of invoices to 1817035 Ontario Ltd. Or corporation, then we would also need to put that name down as an also known as. Because the problem is this: if our invoices for the $12,000 state that they're to 1817035 Ontario Ltd., but our defendant is 1817035 Ontario Inc., the clerk in all likelihood is not going to give us judgment because they're two different names. So we have to make sure that when we prepare our plaintiff's claim that we thoroughly check all of our documents to make sure that we have included all of the names by which we have identified the defendants. Very important in the process. Now, here's one more thing. Although we have gone through and completed these forms, if in fact your plaintiff's claim has been issued electronically, you can also file affidavit of service, request noting default, and your default judgment electronically as well. If it's your intention to note defendants in default and request default judgment electronically, very simple. You go into your OneKey account, you go to the claim which was issued electronically, just go over to the right hand column where it says next steps, and there you can see OneKey allows you to choose a next step, which could include amending a plaintiff's claim, filing an affidavit of service, filing a request to note defendants in default, or a request for default judgment, and even a notice of discontinued claim. Just select whichever one that you need to complete and simply follow the instructions as they're presented. Just that simple. Plaintiffs often want to run out and note a defendant in default if a defense hasn't been filed within the 20 days. I'm going to suggest otherwise. There's something I call the 499 rule. I once heard a deputy judge state that in 499 cases out of 500, a default judgment will be set aside on motion to allow a defendant to file a defense. So how do we get around the 499 rule? Well, it's simple. Here's what I do. Instead of noting a defendant in default, I'll send them a notice. The notice will state that the 20 days has expired and that my client is now in a position to note default, obtain default judgment, and proceed with enforcement procedures. However, I also state that my client has instructed me to instead give the defendant an additional 10 days to file a defense. Now, what I do is I make sure that that communication gets into the hands of the defendant because I forward it in as many different ways as I can. Regular mail, registered mail, email, and perhaps courier. Now, if that 10 days expires and a defense still hasn't been filed, I'll go through the same process a second time, giving the defendant yet another 10 days. And if a defense is not filed in that 10-day period, that's when I'll obtain a default judgment for the client. Now, why do I do this? It's simple. A motion under Rule 11.06 to set aside a default judgment requires, among other things, that the defendant provide to the court a reasonable explanation for the default. Well, it's a little difficult for a defendant to go before a judge and explain a reasonable explanation when they've been given not one, not 2, but 3 opportunities to file a defense. It's my personal experience that at least 2 out of 3 motions to set aside will be dismissed if this particular strategy is followed. So with that, I'm looking forward to seeing you again for next week's video. Have a good week.